Microunit 1, Overview of Disability Laws. So in this module, we will cover the legal landscape for students with learning and attention issues and the ways in which the legal landscape has changed regarding rights and protections for these students. So let's do an overview of the laws that we will cover in this microunit. As you know, there are federal and state laws that protect the rights of an individual with a disability. And here we will focus on and do an overview of Individuals with Disabilities Education Act, or IDEA. We will also talk about the Americans with Disabilities Act, ADA, Section 504 of the Rehabilitation Act, and then the more recent dyslexia laws in the various states, and also the READ Act. For those of you who are interested in how the laws have evolved and changed over time, basically a timeline of special education history, I provided a link on this slide. You might be interested in checking that out. So let's start with the Individuals with Disabilities Education Act, IDEA. This applies to public schools and all schools that receive public funding. It is a federal legislation, and the intent of this law enacted by Congress was to ensure that children with disabilities have the opportunity to a free and appropriate public education, or FAPE. It's been revised, amended several times since then. The last amendment was in 2004, so it is coming up for another amendment. It gets amended around every 10 to 15 years. And the idea is to protect the rights of children with disabilities and also give their parents a right and a say in the child's education. So the major provisions under IDEA, as you can see on this slide, there are 6 major provisions. Let's take them one at a time. Free, appropriate public education. It's based on the value that every student can learn. And accordingly, all students with disabilities are entitled to free, appropriate public education that is designed to meet their unique needs and at no cost to the parents. So the ideas, provisions relating to FAPE are based on the 14th Amendment, which guarantees equal protection under the law. Appropriate assessment. When we're talking about the diagnosis and placement of students with disabilities in educational programs, what the IDEA states is that you must use non-discriminatory and multidisciplinary assessments. So, in other words, student testing must be done in their native language or their primary language, or as we now say, heritage language, if that is the language they're most comfortable in and fluent in. Secondly, you must use valid tests and evaluation procedures so as to prevent any cultural or racial discrimination. The assessment tools must be validated for the purpose for which they are used, and you must use information from a multidisciplinary team in making an assessment of the student. Then the third provision is parental participation. And IDEA has a special provision for parent participation in placement decisions and in the assessment and evaluation. Under this provision, state educational agencies and local school boards have to ensure that parents have been informed and that they are part of the group making decisions around placement of their child. Parents have the right to equal participation in this process. They have to be notified of a planned evaluation. They must have access to the planning and evaluation materials and have to be involved in all the meetings regarding the child's placement. Parents can also have the right to refuse any further evaluation of their child. Both parents and the student must be invited to IEP meetings that's the Individualized Education Plan meetings, and IDEA explicitly establishes a role for the parent as an equal participant and decision maker. The fourth is procedural safeguards. So these safeguards include parental consent for testing and placement, requesting an independent evaluation, requesting an evaluation at the public expense if the parent disagrees with the evaluation, participation in the committee that is considering evaluation, placement, and programming for the child, safeguard to inspect and review educational records and challenge the information if needed, request a copy of the information from the child's educational records, and request a due process hearing concerning the school's proposal or refusal to initiate or change the identification, evaluation, or placement, or any of the other provisions of FAPE. What happens is parents are often not aware of the procedural safeguards, particularly parents who may be first-generation immigrants or parents who may not be aware of some of these rights and responsibilities under the IDEA. So as a result, it can become, it is unfortunate when students don't get the rights they deserve because the parents may not be aware of them. The fifth provision is the Individualized Education Program, the IEP, and I'm sure many of you are familiar with this. The IEP is the vehicle for delivering free, appropriate public education to every eligible student with a disability. IDEA requires that the IEP include the student's present level of performance, including how the disability is affecting their involvement with the general curriculum, measurable annual goals, including benchmarks or short-term instructional objectives related to the general curriculum, special education-related services, statement of any individual modification or accommodations in the administration of statewide assessments, projected dates for beginning and ending services, and a statement about how the child is progressing towards the annual goals, how it is measured, and how the parents are going to be informed. The sixth provision is and I just need to say, I've just put them in this order. They're not necessarily in any particular order. But education in the least restrictive environment, or LRE, is another provision of IDEA, and basically states that all children have the right to learn in the least restrictive environment, consistent with their academic, social, physical needs. It mandates that children with disabilities receive education with their non-disabled peers to the maximum extent possible, and that schools should have a continuum of placements that are available, ranging from one end where you have the general education classroom placement with some additional supports or resource room supports or special education pull-out services, right on through to homebound or hospitalized instructional programs. So, as I mentioned earlier, the IDEA was reauthorized, signed into law on December 3rd, 2004. That's the latest. It's been reauthorized multiple times, but that's the latest reauthorization. And final regulations were published on August 14, 2006. So what were some of the changes as a result of the latest iteration of the reauthorization of IDEA? One was that local educational agencies were no longer obliged to show that there was a significant discrepancy between achievement and intellectual ability in order to identify a student as having a specific learning disability. So for the longest time, the so-called discrepancy formula had been the benchmark for diagnosis of learning disability, and the IDEA recognized that such a formulaic approach was a disservice to students for a whole host of reasons. One is it was a wait to fail approach, and until you could show that 1.5 standard deviation difference or 2 standard deviation difference, children were not being eligible for services. So that was one change. And the other change was that schools had the option to use the response to intervention, RTI, as part of their evaluation process. So this slide provides a summary of some of the thoughts in IDEA. Clearly, there is a lot more than what I have highlighted here. But just to summarize, the intent of the IDEA hasn't always been realized, as I mentioned earlier, and because of lack of awareness, or because of the fact that sometimes this has been a contentious process between parents and educators being pitched on either side. Secondly, a big challenge is that students who are served under the IEP and those who are served under a 504 plan receive different services, and it has kind of created this ongoing rift between 504 services and the individualized education program services, not necessarily a responsibility of the IDEA, but that's how it has evolved. And lastly, again, we'll talk more about this in this microunit, the fact that IDEA and the ADA have not always been aligned. IDEA is the K through 12 legislation. ADA typically applies to individuals in the post-secondary and the place of work, and the lack of alignment between the two laws affects students transitioning from high school to college, and that has made it a challenge for many students. We'll talk a little bit about that in the second microunit. Let's move on to the Americans with Disabilities Act and the Americans with Disabilities Act Amendment Act of 2008. The ADA defines an individual with a disability as a person who, A, has a physical or mental impairment that substantially limits one or more major life activities, and now they've added bodily functions, has a record of such an impairment, which is basically a documentation, or is regarded as having such an impairment. The regarded part does not bestow the provision of accommodations. It's really the strongest arm of non-discrimination. The point is that the ADA is a non-discrimination law. It's not a special education law. It's a civil rights law. Hence, the provisions under the ADA are about equal access rather than IDEA, which is about academic success, which is about performing at the level of the general curriculum. So there are some significant differences between the ADA and the IDEA. Another one is that the ADA is non-categorical. As you can see, its definition of individual with a disability has those three arms that I just defined. With the IDEA defines 11 categories of disabilities, including specific learning disability, attention deficit hyperactivity disorder, traumatic brain injury that was added later. It's basically 11 categories, but some states have a few more. So what has changed with the amendment of the ADA in 2008? What we now have is a new expanded definition of what are major life activities. This new expanded definition of major life activities includes learning, reading, concentration, thinking, as well as then bodily functions such as respiratory, digestive, immune, etc. So you can see if someone has difficulty that impacts a major life activity such as learning, definitely specific learning disabilities and learning are covered under the ADA Amendments Act. Again, concentration and ADHD covered under the ADA Amendment Act. One thing to clarify here, anxiety per se is not a disability. So test anxiety, unless it rises to the level of a generalized anxiety disorder, is not a disability covered under the ADA. But the ADA also covers impairments that are episodic or in remission, such as they may, beg your pardon, they may be in remission, but if it impacted a major life activity when active, it's covered. So this can range from migraine headaches to seasonal affective disorder to more serious psychiatric and emotional disturbance, as it's called in the K through 12 population, which can be episodic, such as panic disorder or obsessive compulsive disorder, and so on. Another change under the Amendments Act, determining whether an impairment is substantially limiting must be made without consideration of the ameliorative effects of mitigating measures. So you can't say, well, somebody has ADHD, is now on medication, and therefore that ADHD no longer impacts test performance or assignment completion, and so on. So mitigating measures cannot be used as an excuse to not provide services and accommodations. And mitigating measures are elements such as medication, assistive technology, auxiliary aids, study strategies, and any other adaptive neurological modifications. And also, finally, the ADA Amendments Act made it very clear that you cannot cherry pick the disability documentation for one piece of evidence or one single subtest to say that an individual is not disabled. And this is from Salome Hayward, fairly noted disability lawyer, who was very clear to state that the ADA amendments cannot be interpreted narrowly, but needs to be interpreted much more broadly in terms of the information provided in the documentation and the consequent accommodations or services. So the Amendments Act did provide some changes, but what still remains the same, and this slide shares some of that. First of all, individuals still have to prove, and I'm calling them individuals and not children because now we're in the post-secondary and the world of work. So individuals still have to prove that they have a disability from a qualified professional. The ADA still maintains that criterion. Also, the ADA's position on fundamental alterations and undue burden, those concepts have not changed. Let me talk a little bit about what I mean about fundamental alterations. So if a student at the post-secondary level is requesting a certain accommodation that is deemed to cause a fundamental alteration to the curriculum or the program as the institution has set up, then that it may not be regarded as a reasonable accommodation. Undue burden, the institutions cannot say that this is an undue burden or a cost to this particular office or disability services, and therefore we cannot provide you with this particular technology or accommodation. When we're looking at undue burden, you have to look at the entire budget of the institution, the college or the university. So the undue burden argument often does not work when offices or individual offices or departments say, well, we can't provide, let's say, sign language interpreters because they're frightfully expensive. We're going to provide, let's say, class notes. So that argument does not fly. And also, post-secondary institutions, high-stakes testing agencies still have the right to determine what are reasonable and appropriate accommodations. Where the amendments have really shifted is in determining who is an individual who has a disability and is eligible for services. So the determining of disability status has really shifted with the amendments, but determination of reasonable accommodations, at least under the amendments, was still the purview of the institution. Later on, I will talk about how even that has changed or is changing, evolving. In this slide, I briefly talk about the Section 504 of the Rehabilitation Act. Again, this one is more aligned to ADA rather than IDEA, but many students in schools receive services under Section 504. Section 504 is a civil rights law that prohibits, again, so it's not a special education law. It prohibits discrimination against individuals with disability, and it ensures that a child with a disability, again, has equal access to education and can receive accommodations and modifications to the general curriculum. So Section 504 really focuses on accommodations and modifications, not a full-blown education plan like you would have under an IEP. If you're interested in knowing more about Section 504, I have included a link there, so check that out. For those of you who are interested in really learning about the difference between an IEP and a 504 plan, I've included a link from understood.org, really easy to understand, explain. This is something you can share with parents if you're working with parents or you're providing oversight of in-service teachers, just so for folks to understand the differences between an IEP and a 504 plan. It's a nice little comparative chart that the understood.org link provides. So again, something for you to check out if you're interested. The dyslexia laws are a very recent occurrence. These laws are at the state level, not necessarily the federal level, and they describe what different states are doing for addressing the needs of students with dyslexia in their state. As you can see in this map, all the green states are the states that have dyslexia laws on their books. I think there are only about 11 states that currently do not have dyslexia laws. And again, if you wanted, these laws address screening, address accommodation, services, placement, but very targeted and focused on students specifically with dyslexia. And again, I've included a link there from the Dyslexic Advantage website for you to check out some more information on that. Very recent and a real coup for proponents of students with dyslexia around the country. In this slide, I have just included some of the details of the dyslexia laws. As you can see, they focus on different things in different states. In some states, the dyslexia laws are about defining who are students with dyslexia and other language-based learning challenges. They have protocol around early screening and identification of students with dyslexia in K through 3. Procedures for states and schools for screening, again, and intervention. There are protocol for training and professional development. LCERT through Landmark and Landmark College are involved in some of these professional development trainings. Education about dyslexia in teacher prep programs, accommodations, and also funding for programs. So as you can see, a wide range of different focus or foci on dyslexia statewide.